Adam and I specialise in commercial dispute resolution. And in the next 10 minutes, before we move on to a bit of a Q&A session, we wanted to start by trying to bust a couple of myths regarding smart contracts and dispute resolution. And then look at what mechanisms you might use to resolve smart contract disputes. And then finally turn to a few scenarios to illustrate how even if everything's perfectly coded, real life can intrude and disputes might arise, even if everything else is operating perfectly. If there's one point I think we wanted to emphasise, it's that although I think there is regrettably plenty of scope for disputes to arise in relation to smart contracts, if you identify where those disputes must lie at the outset, when you're setting up the system and take legal advice, that there are many ways that you can mitigate those risks. So the first myth really that we wanted to debunk is that smart contracts will entirely prevent disputes arising. People often say to us, this will be redundant because code is essentially a contract and nothing can go wrong. And certainly the decentralization and automation can reduce a large number of types of risks, reduce certain types of counterparty risk, create double records, obviously, and avoid single points of failure that exist in centralized networks. But the technology does at the same time raise some fairly novel legal issues and the potential for new types of disputes to arise. And we've really identified on the slide what we see as the five principal potential disputes risks in relation to smart contracts. And the first and most fundamental is really whether a legally binding contract or contracts exist. Obviously, there's one question as to whether a legally binding contract exists in relation to the smart contract. But there's also another, the kind of layer above that, as to whether there is a binding legal contract between participants in relation to the blockchain, so between miners, end users, administrators. And that uncertainty exists because in many common law jurisdictions, a contract can only be valid if it's entered into by a person, so a human or a legal person, with legal capacity to do that. And in addition, there may be certain requirements as to formality in a lot of jurisdictions. So, for example, there might be a rule that a contract can't arise if there's insufficient certainty as to who the contracting parties are. And there's also uncertainty, even if you've got a legally binding smart contract. There's uncertainty as to whether there are any non-contractual duties owed as between those parties, but also as between miners and end users and administrators who might be involved in the system. Now, in English law, certainly, there is a well-established legal test for establishing whether one party owes non-contractual duties to another, even though they're not parties to a contract. But there's definitely considerable scope for argument as to how those principles would map onto decentralized ledgers, especially where the participants are pseudonymous. So that's the second big risk from our perspective. The third is that if something goes wrong, I think one of the questions earlier alluded to this, it's difficult to know who you should sue, either because it's not clear factually who is responsible for what's gone wrong, whether it's a loss that's been caused by a bug in the operating system or defective code, or more fundamentally just because it's difficult to identify the person behind the pseudonym. But the fourth risk that we've identified is really the risk of satellite disputes around dispute resolution. And the decentralized nature of blockchain, with obviously nodes in multiple jurisdictions potentially, means that there is a real risk of satellite disputes about which courts have got jurisdiction to decide a blockchain dispute and what law they should apply to decide it. And that's still a relevant issue, even if your smart contract provides for an arbitration mechanism, like everyone discussed, we were discussing yesterday, because where that arbitration is seated, where it's located, will often be subject to the law of that jurisdiction. So even if you've got an arbitration mechanism, the arbitrator's powers will be subject to the supervising jurisdiction of the court. So arbitration is potentially a large part of the answer, but not the whole answer. And finally, there's the question of trust boundaries. And obviously, smart contracts will often need to interact with other systems or oracles. And even where the agreement between the participants to a smart contract is working perfectly, and has got a dispute resolution mechanism like an arbitration mechanism, there's going to be a question over how that applies across the trust boundaries. So if an oracle malfunctions and you potentially have a claim against them, what mechanisms you use to resolve those disputes, even though as between you and your counterparty, you've agreed a mechanism. So that's the first myth that we wanted to talk about. The second is this idea that the courts somehow can't intervene in the operation of smart contracts or resolve smart contracts and other DLT disputes. And certainly the legal uncertainties that we've mentioned and the kind of novel fact patterns involved in smart contracts present some real challenges for the courts. But certainly the English courts are pretty adept at applying established legal principles to new fact patterns. The difficulty is that there tends to be a period of uncertainty, both while they get up to speed with technology and also while the common law develops precedents in relation to new fact patterns. So I think it's just important to keep reflecting on the fact that smart contracts don't exist in a judicial vacuum. But having said that, a lot of those risks can be mitigated by some careful drafting at the front end and ensuring that where you've got smart contracts within a permissioned or a hybrid system, you ensure that the participation agreement sets out the participants' rights and obligations and the resolution and the mechanism for resolving disputes as between them. And then also smart contracts are either governed by some kind of master agreement with a dispute resolution mechanism or incorporate one into the individual contracts. What we wanted to do now is I think Adam's going to speak briefly about some potential options for dispute resolution mechanisms that you might want to think about.
Thank you. So let's assume you recognise that you might actually have a dispute and you realise you do need some sort of dispute resolution mechanism. I'm just here really going to queue them up in a sort of list format. Some of them already exist, some are coming into play at the moment. And then after that list, we're going to move on to look at a few example scenarios. Hopefully that will stimulate some questions and discussion, and we can look at how these mechanisms might work, how you might actually need them. So this is really just a quick laundry list at the start. And first, I'll deal with the case of the permission blockchain. That's sort of a separate and discrete point. And there are, while it might not be perhaps in the spirit of a lot of different blockchains, there are a lot of use cases around permission blockchains that are sort of in the offing at the moment. This is a blockchain where, in order to participate, there is some sort of mechanism to obtain permission, there is some sort of relationship between the parties involved, and there is a consensus mechanism that therefore is finite, is constrained, and one assumes is either implicitly or explicitly under the control of a particular party, the one who set it up. Let's call them the administrator. And here, if you have some sort of dispute and something that needs to be resolved involving the blockchain, in one sense you've got a very simple answer. You can go to the administrator. And they, in a sense, let's assume, have godlike powers, and it becomes easier to deal with really than disputes in reality apart from the permission blockchain. They can just decree that things should be so. On the one hand, that sounds very simple, but if you're an administrator, you would be very reluctant to do that. With that great power comes great responsibility. What sort of liability would the administrator have for interfering? How would that affect how the blockchain as a whole works? So you need to look quite carefully at the start at how they become part of that mechanism, how you set up the different responsibilities. But nevertheless, that's the way that it would proceed with the permission version. With a non-permission version of the blockchain generally, obviously you've got the option of litigation. Litigation doesn't necessarily know about the blockchain. There may or may not be expertise there, but in fact, judges, particularly in the English courts, are used to dealing with highly technical areas that are not necessarily within their expertise, but they can get expert evidence on. So we can assume that in fact they could come to grips with some of the issues. But bear in mind that they won't actually care about the blockchain. In terms of how they resolve the dispute, they will just care about reality. And the intersection between those two could cause some problems pretty much for the blockchain as more than for the courts side of things. But we can come on to that later. But so what you may want is something that has a bit more of an intersection between reality and the blockchain, something that you've set up in advance, some sort of arbitration mechanism or some form of alternative dispute resolution. And you need to decide for that arbitration how much you're going to build into the smart contract. And you want to build it in to some extent to make it work efficiently, how decentralised it will be, who the arbitrators will be, all those sorts of questions. But the key one is how it fits in, how it intersects. Do you want to set it up so that you can just stop the execution of the smart contract and go off to some other code path, if you like, if you've got arbitration? Does that mean the contract isn't smart or automated anymore? Do you want to, that's sort of at one end of the spectrum, at the other, you don't really allow the autonomy of the smart contract to be interfered with, but how are you going to enforce the arbitration? In between those two, you have some sort of mechanism set up, multi-sig or something like that to allow an arbitrator to be appointed to allow them to do things on the blockchain. That's probably the sweet spot, how you would want things to work, how you want them to be resolved. But there's a lot of detail there that needs to be worked out between the coders and the lawyers to make that work effectively. So I've just queued up that list. There's a huge number of issues there, but I don't want to take up all the time. So I think we can take questions generally on anything that's blindingly terribly wrong that we've said so far, or we can queue up some of our example scenarios, which will hopefully challenge some of the preconceptions and make you believe that some of these disputes really can come up in reality.
Okay, thank you.
No, not muted. Good. Why don't we just spell out some of these example scenarios, just in case they throw up some
questions.
Yeah, certainly. So everyone can read the first scenario here we've got. A platform that's working perfectly, but the trader's 3-year-old walks into the room when he's on the phone, finds a computer logged on, presses the button, executes a trade, and that trade executes automatically. Now, the reason that we've chosen this scenario is because I think it's a nice example of how even when everything's operating perfectly, technically, real life can sometimes intervene. And here, the question is, well, is Y Bank bound by this transaction that was entered into by a 3-year-old by mistake? And it raises the question, well, from an English law perspective, you'd argue, well, Y Bank, that child didn't have legal capacity to enter into that transaction. Y Bank, if it left it out of the money, it would want to unravel that trade. And so even though it's something that's indelibly recorded on the blockchain, what does Y Bank do? Well, depending on what dispute resolution mechanism is built into the platform, it may well find itself going to court and arguing, well, this transaction is void, even though it's been executed, we should be able to unwind it.
I think this one is why you need a dispute resolution mechanism. Kudos to the people who wrote this software, it's perfect. There are no flaws in any of the code. They've done it all 100%. Exactly. We need these people. They're better than NASA or whoever. So let's assume that everything is perfect. That it's all worked properly. Nevertheless, we could have the sort of the legal discussion up here as to whether it's valid or not. That'd be very interesting for us, but perhaps not for all of you. So let's assume that in fact the contract is vitiated there, despite your best efforts. because the button's been pressed by the 3-year-olds, there isn't a contract from a legal point of view. Yeah.
Sorry, surely this is a system for a 3-year-old should not be able to execute that trade.
Yeah.
They're not authorised to do so.
Yeah.
And if the system enables hit enter to execute
yeah.
an extremely large trade, that's a system.
Yeah. Well, the trader did use the iris and retina scan and everything else, but at that precise moment that he'd gone through the several factor authentication, he just had to rush out for some emergency and his daughter rushed in. You know, that's what happened.
I think we're stretching around something.
That may be a little unlikely, but we can imagine certain other scenarios. You know, CAL fraud. I mean, somebody might indeed have access, and the company fully intended that they have access, but the subsequent actions result in there being no valid contract.
I mean, I think there is an argument there in terms of, well, let's try and push these fact scenarios out to the margin so much that we can just say the cost of having them we just accept, and let's just go with the code because it's 100% and ignore these odd fact patterns, if you like. That is an argument that's made. It's the argument for when you stop at the red traffic light in the middle of the night. You should still stop even though you know there's no traffic coming the other way. The sort of philosophical side of things, but it's not the way that legal systems will work. You will be able to come up to, we've got other ones apart from this, you will be able to come up with fact patterns where you've done everything right, but something else supervenes. Fraud is the example. I mean, we could look at one of the, another example scenario. But this is trying to make the point that even if you do it perfectly, you might not have a valid contract.
Yeah.
How do you deal with that?
I mean, it's very clear that there's so much, for example, unreliable hardware, there's human error. This stuff has happened in live trading systems that were not on blockchain any number of times. We know that the real world works this way.
Yeah, fat finger trades happen all the time.
Question?
Yeah, so legally speaking, who actually executed the trade? Because we've been talking a lot about...
I assume that's part of the thing. Conference works.
So we've been talking a lot this weekend about what is identity in the blockchain. We said there's some binding between some private key and some set of claims that here's this real world person that owns that real world key. But in this case, the person who owns the key and the person who authenticated that key is the person who actually executed the trade. So would it be the identity of the person logged in, or would it be the 3-year-old who actually executed the trade?
Yeah, I mean that's a good question. It's an interesting question. It's going to depend on the particular facts, and I can hand over here to a particular thing, but I don't want to get too bogged down in that.
Well, I was going to give a very short answer to the question, which is that this is exactly the sort of question that needs to be considered at the contract negotiation stage, and you need to have an express term in the contract which says, for example, that any trade executed on the system using this security mechanism will be binding on the person whose identity was used to make the trade, even if they want to contend that it was actually the 3-year-old. The answer is you need to think about that in advance and have clauses in the contract which tell everybody what the answer is without needing to have a dispute or an arbitration.
Peter?
I think it's interesting that the technical reaction to this is it shouldn't happen. And Clive's reaction is the contract should take care of it. And I agree with both. But there is a third scenario, which is that look at this as an example of something which is completely unexpected. It may be this is not a good example of something which is completely unexpected, but at some stage something will happen that is unexpected and is not dealt with by the contract. And then the lawyer says, the judge or the arbitrator or the person who's advising, we must deal with the situation which has arisen, which nobody has anticipated. Well, you can deal with it in a number of ways. You can say the onus was on the person who built the system to make sure it didn't happen, that nothing unexpected happened. You could say that the onus was on the person working at home to make sure that his child or his dog or his budgerigar didn't get in contact with the machine. Or you can say this is something that should be dealt with by insurance. But as far as the law is concerned, the law would struggle to come up with a just solution. I don't think it's up to us to say what the solution would be, but it just underlines the facts that you cannot anticipate everything that can go wrong.
Isn't that the situation we're in today? With our current system, with or without crypto?
Yes.
Yeah.
Yes,
Why
exactly.
do we expect to all of a sudden solve it overnight?
Well, they don't. The point about having the smart contract is more things will be anticipated. The solution will be imposed, will be better, and hopefully it will be cheaper to get going, and therefore cheaper in the long run because you won't have to spend so much money on getting the problem resolved.
To which I completely agree, but these are all relative terms. We're not going to solve it overnight, that's okay.
I'll just ask, in terms of avoiding these situations going to arbitration, is there going to be some sort of mechanism where something like this might happen, will go to arbitration, and when the result of the arbitration is made clear, will that then feed back into the system? So the thinking will have been done in this case where the child's done it, and everyone will be able to see this is what the outcome is going to be because it's already been arbitrated. So both sides will know in advance. So it's a sort of self-improving system.
Well, exactly. I mean, and the idea is that if you have unexpected situations that you need to deal with that go to the arbitrator, the intersection between what the arbitrator can do and the smart contract allows them to automatically then enforce what that decision is. So if here it is, say the decision is to cancel the trade, the idea would be that the arbitrator, appointed according to the dispute resolution mechanism, once it's come to that view, is then able, by virtue of their appointment, to actually execute that on the blockchain, so that it's still smart in that sense. The dispute is then resolved, the assets and money, whatever, flow through to the right person as part of that smart contract dispute resolution mechanism.
Yeah, all future smart contracts to know that that is the case.
So does it become precedent-based, is the question?
Well, for the actual decision.
Yeah.
Well, you've still got I suppose, a legal case behind it, and so an arbitrator, you're sort of into the law of arbitration there, where it doesn't necessarily set a precedent, won't necessarily be publicised, could be confidential, could be on the blockchain, could set a precedent. Yeah.
There are two strands to this question. The first strand is, to what extent are the decisions going to be made public so that other people know about them? The second strand is, once they are made public, are they going to be binding for future cases, which really raise the same sort of problem? I think there are three purposes for having an arbitration scheme. The first one is to give the users of the system the confidence to know that if they have a dispute, there are specialist decision makers who will be available to decide that dispute, who will have an understanding of the technology. The second aim of an arbitration scheme is so that users of the system, if this is how it's done, can see that decisions are being made by specialist arbitrators and can see that those are sensible decisions. The third purpose of the arbitration scheme is so that the participants can see, the third aim to achieve by an arbitration scheme is so that the users of the system can see what's gone wrong in other cases and can learn lessons from that and build their systems to prevent the same thing happening in the future. But all those three aims require that there should be some publicity given to what's happened in individual cases. Traditionally, arbitrations don't happen in public, they happen behind closed doors. But I think we need to consider in this situation possibly having some kind of publicity to the decisions. It can either be full publicity in which everybody knows who all the parties were to the dispute with their names being mentioned, or they could be anonymised decisions, and there are precedents for this kind of system. The ICC has a .dex system for expert opinions in disputes relating to trade finance, in which the actual experts who are asked to give their opinion don't know the names of the people involved in the dispute, and they issue an anonymised decision. opinion. It's not in this situation a binding decision unless the parties want it to be, but they issue an anonymised decision which everybody can see. So those are the three different ways of doing it. That's the publicity side of it. The other side of it is, are these decisions going to be binding in future cases? As far as that's concerned, there's a real danger with having binding decisions, which is that if a bad decision gets made, you're stuck with it. There is the risk of that happening in the real world with the court system, and that's why we have a system of appeals to deal with it. But once you start talking about appeals, you've got a greater level of complexity, you've got greater cost for the participants. So you have to decide which of these routes you want to take.
Probably the arbitration.
If I could just add a fourth aim in this kind of scheme, picking up on the point that Adam made, I think it's worth emphasising. There's something quite novel here that wasn't possible before. And this is the scope for direct enforcement of an arbitration award by an appropriately authorised arbitrator. This is really quite new and exciting. There are plenty of cases you can point to where a party who's successful at arbitration takes the award to a national court where perhaps there's some corruption, for whatever reason, they're unable to have that award enforced. The reason they had to do that is because the asset they wanted to seize to cover the debt, for instance, would have been in a particular jurisdiction. And it's the court of that jurisdiction that they needed to go to achieve that enforcement. What we have here now is this interesting possibility that there may be value on the blockchain. Something that is there, it might be because there's an escrow amount, it might be that there's other trade within the same system, but there might be something available there that has value, against which an award might be enforced. And that's something quite new, and I think is especially relevant in cross-border disputes. I don't know if there's anything to add to that, or...
Should we do very briefly scenario 2? Sure. So scenario 2, I think it's almost the same, except we've tried to come up with a fact pattern where you're even more convinced that the trade ought to be cancelled, and where it would be quite difficult, I think, to set out in the contract saying it wouldn't be cancelled in those circumstances. Although I'd be interested to get the other panelists' views on that. Basically, because you've got the fraud.
Definitely not one.
It's good to know that this is not based on an actual scenario. There is a doctrine of common law as applied in this country and other common law jurisdictions, that if something goes horribly wrong, then and the contract cannot be carried out the way that was intended, then it all falls to the ground. It's called the doctrine of frustration. And there's a possibility, I don't say more than that, of applying that solution to this particular situation. Otherwise, it's merely another example of something unexpected going wrong.
Yeah, so I think it sort of raises the points of the previous one, but more extreme. Should we look at the next one?
Yeah.
That's got lots of sort of technical bits that you may be interested in here. And this is where there is a smart contract mechanism, a payment of £1 million that should be made into US dollars, that's being made in US dollars. And unfortunately they do it as $1 million LBP, or I'm sure they're Liberian pounds. And £1 million Liberian pounds is about 600 US dollars. So that's the amount that gets transferred by mistake. And this one is illustrating some of the different ways it can go wrong, and the different people who might be liable, who might be responsible for it. Someone's mentioned insurance before, which I think is quite important here. And if you decide some of these are just too complicated to deal with, that might be a way out. We'd be interested to have views of the panel and others as to who is responsible for these different sorts of errors, and if you can avoid them.
Clearly the programmer is
responsible because they're using the words GBP, LBP, and so forth. And if they were using recurring contracts, that mess would never have happened.
Yeah, well, when you say the programmer, when we've put there will be a number of programmers, wouldn't there? Right? It may have been an error in the transcription of the code part of the Ricardian contract. It could be that the contract was written out perfectly, but there's some error in the code in the platform itself that translates it wrongly. The error could be on the buyer side, the seller side. It's sort of the first bullet point there, if you like, is intentionally.
Well, I grant that there could be a swapping of one hash for another, but even that would be an extremely grave error.
Yes.
But I would say that if that is happening, programs are responsible. This is the question you're trying to ask.
But let me generalise this, because this leads to a very interesting discussion. Conventionally, in contract, you have your two parties and they're negotiating the contract between them. This is the case. Okay, so let's take the example where there's a bug. There's a bug in the smart code. Not this kind of grave error. Something that was just an unanticipated bug. And it may come to light that this bug is there. And indeed, there might be a straightforward patch that could be applied, as it were. And then the question is, well, exactly how is that going to be achieved with this smart contract on the blockchain? If the two parties are going to have to get together and decide between themselves, oh dear, yes, we didn't really intend that, we'd better get around to scrapping that and rectifying the situation. By that time, someone may have siphoned off all the value of the smart contract. So I think in this environment, yes, there's a question of who would be liable for that kind of bug. Somebody's drafted the software. Was it jointly drafted by the two parties? That's one angle to go down. Another view on it is, well, maybe we should be looking to have third-party creators of the software here. So that there's an unambiguous party both liable for any errors and therefore motivated to maintain it.
There's a prior question, if you like, which is anyone liable? You could say, well, I wrote this million lines of code, I open sourced it all, it was perfectly open to you to see that it would pay in Liberian pounds in this situation. And therefore everyone should simply be held to the smart contract as reflected in the code, and no one is liable for anything. Would anyone take that view, or does anyone think there is a problem?
Can I come at this stage? One way of looking at contract law from a jurisprudential point of view, in other words, legal philosophy, is that it's all about allocation of risk. So the first point of talking about allocation of risk is what the contract says. So any lawyer faced with this problem looks first at the contract and says, does the contract lay out who takes the risk of this happening? This is a general approach. If the contract doesn't, and you go to some other form of dispute settlement mechanism, let's say an arbitrator, the arbitrator will say, well, what would I expect the contract to say about the allocation of risk? It may be, as has been suggested, the loss lies where it falls. In other words, there's no specific allocation of risk. It may be that the correct answer is the risk is allocated to one party than the other. It may be that you have the frustration answer, which is that the whole contract falls to the ground, it comes to an end and cannot be enforced. Or it may be that the risk is apportioned, partly because it's the fault of one party, or there may be a contributory fault by another party. But these are all questions that have to be answered in the light of the particular facts. And I don't think you can just say there's bound to be one particular answer to one particular problem. Everything is fact sensitive.
That's a question.
Hi, so fascinating discussion. I thought it was a lot too. I'm going to give one other again. I'd love to hear your comments. So in Estonia and elsewhere, they were asking this question in the context of self-driving cars. You know, that self-driving car, self-owning car, crashes and kills someone. Who's responsible? Is it the car maker? Is it the programmer? Is it, you know, one of many other parties, right? And what they arrived at was, well, what if we give the car itself rights? But not just rights, responsibility as well, because you know, if you put the self-driving car into jail, it doesn't really care. But if you give it a combination of rights and responsibilities, when it tends to fail, you can take away some of those rights or responsibilities. So they arrived at this, and then they realized, you know, this applies not just to self-driving cars, but to broader AI. And this is what we're working on with this CRAP law, or I like to call it AI residency. But my point is here, many people have framed blockchains as life forms or as AI, and this is actually possibly a way forward here as well, where this smart contract, this very minimalist life form, maybe it has rights and responsibilities. I'd love to hear your take and if you see other initiatives beyond the CRAP law.
I think the thing about lawyers is, one of our first questions might be, well, does this life form have any assets? Because otherwise it's not just what he's suing.
Which is 20,000 or 50,000 euros versus pieces of metal and silver.
Right. And so that's the thing. If you've got assets tied up, whether you characterize it as a thing that has something that might be taken off it, or you characterize it as putting aside funds as a kind of self-insuring policy, or whatever it might be.
I mean, we've actually looked at this in the context of autonomous vehicles, and I think that the connection between that scenario and this one isn't AI as such, it's autonomy, and the fact that you've got an autonomous agent. At first it seems very far-fetched. Then the EU Commission has actually published something on it, you know, putting out the idea of having the sort of autonomous agents given legal personality. I think it still seems far-fetched, and the EU Commission saying something doesn't necessarily stop it seeming far-fetched, but that's another issue. But what I would say is that over the years, the common law in particular has been able to come up with novel ways to incorporate these scenarios and make them work properly in an economic context. And we've granted personhood to lots of entities that are not actually natural individuals. So it would be, you know, despite sounding far-fetched, it would be about a way of achieving that allows you to achieve whatever aims you've got in your jurisprudence, to come up with sensible answers and to allocate risk and liability sensibly.
Am I on? Is the microphone working?
Yes, yeah.
Right. The way this jurisdiction has solved this problem with regard to uninsured human beings is to deal with the human being for lack of not having insurance separately under the criminal law system, and by the Ministry of Transport, as it was then, making a deal with the insurance companies to set up the Motor Insurers Bureau, so that the last insurer of the vehicle is liable for the loss. So a possible solution here would be to make, by way of statute, it compulsory for the machine to get itself insured, which could be done by programming the machine to take out insurance and arrange for payment, no doubt by way of a blockchain mechanism, with a default position that a nominated insurer or insurance body, or failing all else, the state would pay the damages.
Do you want to look at the fourth scenario?
I mean, I think the rest of these are all about sort of allocation of responsibility to different people, so they're covered by these sorts of points. That's in one side. Is there any question?
Yes, hello. I just one final point on the autonomous car, stripping it of rights or something like that. It just seems to me that there's no actual repercussions for a non-thinking computational entity. You know, what am I trying to say? Basically, if the repercussions don't fall back onto the humans who coded it, you could essentially have a sneaky coder who decides to make the car kill 1 in every 10 people, and then it's just the car that gets stressed. Never comes back.
Yeah, I mean that's exactly the issue you need to deal with.
So I'm interested in the situation where we talk about the kind of blame slinging or risk kind of hot potato. But why don't we, for a moment, assume that there's no blame whatsoever, which was predictable at all in this situation, and that the data set happens to be built on top of a lantern and a cosmic ray hits the register after all of the protections which had all been reasonably put in place, so that a bit was flipped unexpectedly. And that all parties are quite aware of the fact that there is something which is unsatisfactory to all of them, because perhaps the party who fails to deliver the amount that it expected, their reputation is being damaged by it, as well as all the rest of it. So let's assume that there's a blame scenario and cooperating the parties. Should we not be trying to establish some kind of position where blockchains always have a degree of flexibility, able to be engaged by their judicial system that they're founded in?
And I don't know what others think on the panel. I mean, ideally, yes, but I guess my immediate reaction to that is the more you introduce nebulous concepts like fairness to a smart contract, the greater the scope for dispute. So, as disputes lawyers, most frequently, the things that we see people arguing about are concepts like whether or not a material adverse change has occurred. So you might have a contract that says, well, in the event that there's been what's referred to as a material adverse change or a frustrating event or whatever, then I don't have to perform my contractual obligations, or I have to use reasonable endeavours to perform them, for example. And it's that kind of language where it introduces an element of subjectivity that tends to result in disputes. So I guess that's the immediate challenge I see with introducing those kind of concepts. I mean, I think it's important to remember that where someone has agreed that they will do something, even if it hasn't happened for reasons outside their control, the chances are that if they can still do it, they'll be liable to pay damages to compensate the other party. If they genuinely cannot perform because some extraordinary event has occurred, then as Peter mentioned earlier, they're probably going to be entitled to treat the contract as having been frustrated, and both parties will be able to walk away from it. So I think the English law provides some mechanisms to deal with those situations, even if you don't incorporate them into the contract, if it's English law governed. You don't need to expressly provide for every scenario. You just need to agree what law will govern any dispute that arises. I don't know what others think.
I'll go back to the first answer I gave this afternoon, which is this is exactly the sort of thing that needs to be thought about at the time a contract is made. We get exactly the question of the unavailable oracle in long-term oil contracts where somebody agrees to pay for oil over a period of 20 years and they agree an indexation clause based on a particular named index. And then you find 10 years down the line, that index is no longer available. And I myself have advised in a case where, in that situation, the parties had agreed that there should be an expert determination and the expert should have the power to substitute an alternative index. You can easily build that kind of procedure into these kind of smart contracts.
And I would only add that blame is not a necessary precedent to allocation of risk. In short, you don't need to find someone to blame before you can say the risk must be allocated in a particular way. The risk can be allocated without anybody being to blame, or the person being to blame someone you can't take action against, like a terrorist.
Sure. Question.
I'm curious, I assume that there's a legal intervention in a smart contract, but the smart contract has actually acted and the chain continues. is there concepts in the legal field where, like a network value, I can agree to be part of a network that contains financial value of, let's say, 300,000 euros. So all transactions that are happening within this network should not exceed 300,000 euros. And if a favor happens within this network, this has to be covered within the complete network's resources. So do you understand what I was referring to? Like a kind of almost an industry body that says all arbitration has to happen.
I think what you're suggesting is the risk can be allocated by a pooled system. That is, everybody contributes something, or by limiting the liability of people. And I can only repeat, you can allocate the risk any way you like, but you just need to have the risk allocated. And if you haven't agreed how to allocate the risk, then that can be resolved by a dispute settlement mechanism.
I think in the blockchain space, people are very familiar with the design effort that goes into token economics. It's a kind of financial incentive for certain kinds of action. I think maybe there's another piece that's sometimes required, which is I don't know how to describe it, it's designing the risk, the risk allocation, but just working through where liabilities will fall and whether that's where you want them to remain, or whether there should be some kind of allocation to a particular party, whether you want to pool it, whether you're going to have an insurance scheme. But thought needs to be given to liabilities, not just to incentives.
Should we mention this one briefly? I think this is an interesting one because it's there's no getting around the fact that reality here is different from the blockchain. And if you, having had a moment to look at it, the courts or whatever will allocate that ownership of steel to the person they think owns it. And if you've got what you thought was a proprietary register of steel that you want to use for trading or some other purpose, the problem isn't with reality. The problem is with you. You, the blockchain, have to deal with the fact that you're out of sync with reality. And you will need to come up with some mechanism for doing that. You can't just say, well, we trump reality or we'd expect reality to get in the way. The courts will do what they do. They might retransfer the steel, they might award damages. They're just going to deal with it and you're going to have to fall into line.
Oh, yes. Go for it.
Like I said, the lawyers definitely wouldn't have approved the throwing of that thing.
We did a risk assessment.
Much more basic question. If I'm trading with somebody over a private permission blockchain or maybe a public blockchain, and there is a dispute, how prepared are the courts in various jurisdictions to actually accept blockchain as evidence? And technically, how capable are they of evaluating that?
I mean, it's certainly the English courts are very used to, I mean, it's just an evidential question. The English courts are very used to receiving expert evidence from things that they know, or about things they know nothing about. So what would happen is both parties would appoint an expert, say, coder, and that person's role would be to explain to the court what they say has happened, their interpretation of the facts, explain what the code means.
That sounds like a lucrative new profession.
Absolutely.
Yeah, but it doesn't have to be too. In many cases, in this kind of scenario, the evidence would be uncontentious and it could be dealt with by a single expert, or better still, if it is genuinely uncontentious, the parties could agree what the state of affairs is about that evidence without any need for an expert witness to be paid to participate in the dispute.
And if it was a closed source private blockchain implementation, do you think the vendor would be obligated to somehow participate in that process?
It isn't so much. 9 times out of 10, you don't need to oblige somebody to participate in that process because the very fact of having to participate in it is going to cause them the expense and the risk of having to pay for to meet the cost of that expense is a sanction which brings sense to them in the first place.
So, the sort of language that we use to think about this kind of scenario internally inside of Mattereum is delamination. That you have two layers of reality that are splitting apart. And the place where we see the most sort of likelihood of mess is where one party clings to the technical side and the other party points to the steel and warehouse, and both parties are in fact correct. And that seems like the kind of thing which is likely to remain messy and complicated until you get a body of legal precedent. So even if the contracts that are used indicate it's going to go one way or the other way, different parties might adhere, in different situations the contract will fail one way or the other way, or fall on each side of that line. But in the long run, the general standardization of this stuff at a societal level seems to be the precedent is full. Any thoughts on that?
So, I think interestingly, there's a degree of lamination in the law as well, in terms of, say, ownership of assets, because you take this scenario 4 where there's a disconnect between what the blockchain says and what the court says. One possible solution to that is for the court to, there's that ownership can be split into two parts. There's an idea of being the legal owner and also the beneficial equitable owner. And it may be that the way of reconciling that scenario with real life is to say, well, actually, what's recorded on the blockchain is legal ownership, but in fact, the beneficial owner of the metal is the one that the court decides has beneficial ownership. So, in some ways, maybe that concept of legal and beneficial ownership can adapt to deal with blockchain type disputes. I don't know what others think.
Well, I think my short answer would be there wouldn't be much prospect of the courts of Kazakhstan saying that the blockchain knows better than it does who the owner is.
Yeah, I think that's right, and it's how you deal with it. But I mean, to your point about the different layers, I'd put it as a coding analogy that the idea that you can solve any programming problem by adding an additional layer of indirection. And legal systems do that, as Harriet was saying. That's the approach that they take. And here it's the dispute resolution mechanism that is that additional layer of indirection that allows you to resolve that mismatch. And you need, so at the start, you need to decide what powers you're going to give that additional layer to interfere with your two existing layers that doesn't interfere with the objective of having a smart contract in the first place, but is powerful enough to deal with situations like this.
Yes. Can I just add briefly to what I said? Of course, in this situation, it may be the case that precisely because the parties are concerned about this sort of thing, they say the contract should be governed by English law. And they may also say that they want neutral arbitrators to decide the case so that the decision makers are not the courts of Kazakhstan simply saying what they've been told to say by their legislature. There are ways of dealing with these sort of problems in international trade.
Although we try to pick a situation where simply choosing an English governing law wouldn't necessarily help, because you're dealing with steel physically located in the warehouse in Pakistan.
I just want to make my observation of the last 4 scenarios, and it goes back to the talk that we had earlier about semantics, that the use of the term smart contract here, there is nothing smart contract about, legally anyway, about the use of the blockchain platform here. What seems to be the case in all 4 scenarios is that you have a natural language contract which is legally binding, and that the platform is just an execution method or some sort of evidence of that contract, and therefore you have a disconnect in the law. We always go to arbitrate disputes on the terms of the natural language contract, and the only way you can possibly get around that is if you say in the natural language contract if there's any difference between the wording of the contract and the platform, then you say that the platform wins or the natural language wins. Otherwise, there's nothing smart about what's going on.
Well, I think one can strive for absolute precision and complete isomorphism between one's code and one's prose. But the one thing I don't yet know how the code will provide for the reasonable function or the.
Actually, a lot of problems do come out that way. But I think what we've tried to show is actually not all problems do come about from that mismatch. I mean, you might say that in this scenario, let's say there is no natural language, let's say in some way everything is in the code, you could still get this fact scenario. And it is true that irrespective of words or natural language, a legal system will impose its own idea of what the contract is over and above the code. And it will have things in it like, if there is a fraud, then that will unwrap it, and we don't care what the code says. We don't care what the natural language says. You will have these problems that you will have to deal with because you have a legal system which is separate from a computer. And it's not just about natural language.
Ultimately, however precise the language or other way you've encoded the intentions, we're always going to be able to dream up a way in which that won't be sufficient. And then what really counts is the procedure you set for dealing with that exception. So, I mean, if there's one conclusion I'd like to make from this, is that the procedures for handling the disputes which will inevitably arise are something you really want to get right.
So the trend made this distinction this morning and suggested that the automated part was what you'd use when everything was fine, and it gets increasingly manual as things begin to go wrong. The kind of, Sanitt guys, it's automated, Wray guys, it's going to go manual, because that's just kind of what it is.
Yeah. So can this be done? Well, now up to time.
Okay, so last question.
For the dispute resolution mechanisms that you stated earlier, arbitration and things like that, even if London was the choice of venue that was stated in the contract, what would that do to solve this scenario? I mean, this may sort of reflect my limited geographical knowledge, but Pakistan could just say no to this, right? Like, what could Norton, Fulbright, or anyone else do about that?
So if your contract said that you would, both parties agree to submit to the jurisdiction of the English courts, say, and your counterparty started proceedings in Pakistan, then you can phone up the English courts now and try and get yourself an anti-suit injunction with screening.
I think the question is about the arbitration.
Oh.
The people in Pakistan.
Yeah, must we debate?
We're not giving up the matter.
Yeah, you're right. You would need to go to, on assumption, you would need to go to Pakistan, and there's nothing wrong with your geography, it doesn't exist. You would need to go there to physically move the steel. You could resolve the dispute without moving the steel in a lot of situations. But if you physically wanted to move the steel, that's where you've got to go.
Yeah. So if you're going to deal with a party who only has assets in a jurisdiction in which you can't rely on the local court enforcing an arbitration award or doing the right thing, that's a commercial risk that is difficult
it's not completely impossible. You can hope that there's a bilateral investment treaty between the United Kingdom and Pakistan, and then you can start an international arbitration claiming that your rights have been expropriated.
Thank you. Thank you very much.